for this table, you have a discussion on line finance, and I'd like to thank you, Professor Mariana Pargendler, Professor Ariosvaldo Matos Filho, Professor Sérgio Lazzarini, and Professor Viviane Prado. We're going to start now. So, people, let's go. And please, Professor Mariana, you have 20 minutes.
Okay, so it's so unfair to present after Katharina. Thanks, Mario, for putting this event together. It's wonderful to hear our own colleagues, but also to have with us both Professor David Tribuck and Katharina Pistor, who are as close as we can get to canons in this school. So it's unfortunate that I'll have to present after her. Our panel is about law and finance and alternatives for private investment. Here, I really want to get back to basics, and I want to talk to you about the corporate form, the business corporation, what we call here in Brazil, Sociedade Anônima. It's considered to be a key institution of modern capitalism, and the conventional history is that a history of success and continued expansion to different contexts. There is a large literature on comparative corporate governance. My work is situated in this literature. Let me give you the key takeaways there. There is this idea that there are differences in corporate laws and ownership structures in different jurisdictions. But the corporate form itself is universal. You can find them pretty much in every capitalist economy. So there are certain attributes of the corporate form. I'm here listing the attributes of this book called The Anatomy of Corporate Law. They're fairly consensual. So we have a lock-in, limited liability, delegated management, transferable shares, investor ownership. This defines a corporate form. You can see that everywhere. Does Brazil have business corporations under this view? One answer, guys, is of course, okay? So we have every one of them. This is a defensible view. Now, I've joined this book as a co-author, so I think it's plausible to say that Brazil has a business corporation. Everybody says that Brazil has a business corporation, and that's one view of the world that I think it's fairly understandable and defensible, but I will argue here it's an incomplete view. So I really want to complicate this picture. So I want to show you that really these core elements of the corporate form are far weaker in Brazil than usually assumed, to the point that it's also plausible to argue that we don't quite have a business corporation in Brazil. Moreover, what's somewhat puzzling is that this divergence is relatively recent. So we don't have here the conventional law and development story in the sense that, well, our law is underdeveloped, not sophisticated. We're not there yet. We had a stronger version of the business corporation in the past, but those attributes have been mitigated in the last, say, 20 years. So what then explains this deviation from the norm in other countries? And this is the theme that I want to explore here with you today. So basically, you can have the glass half full and say we do have a business corporation in Brazil, and then do conventional comparative corporate governance, or say that we do not. And here I will explore the view of the glass half empty, trying to highlight our peculiarities. So basically, with respect to all the 5 attributes in Brazil, I can say that we don't quite have them. You know, they're all far weaker. And that's even so, and perhaps more troubling with respect to the first 2 attributes that say that a corporation is a separate legal person whose assets are separate from the people or individuals that hold them. And I'm going to present those differences to you briefly, and then I'll try to think about what's triggering this deviation. First, with respect to legal personality, I mean, for sure, a Brazilian corporation is considered to be a legal person under the law. But here I also want to address an attribute that corporate law scholars have come to refer to as lock-in or entity shielding, which is now considered perhaps the primary attribute of the corporate form. And this is the idea that the separation of assets between the firm, the entity, and its owners or shareholders is strong, meaning that once shareholders have contributed the assets to the firm, the assets belong to the firm, and the shareholders cannot individually withdraw the assets. They can sell the shares, but they cannot withdraw the assets at will. This is what we have on the books in Brazil. So if you read our corporation statute, it's not different from what you would expect in other countries. There is a possibility of a full dissolution decided by court in the very grave situation that a corporation cannot fulfill its purpose. But that's what you would expect from a comparative perspective. However, under recent case law, and this is really well established. So basically, there have been 2 decisions by STJ in embargos de divergência. I've had RAs look into lower courts, and this is settled. Lock-in is gone for closed corporations in Brazil, meaning if you are a minority shareholder of a closed corporation, you can request what I'm calling here a partial dissolution at will, when you want. The way lawyers would frame it, they say that we can do it for a breach of affectio societatis. This is the doctrinal hook, meaning you no longer want to be part of this joint organization. So lock-in, which is considered so critical today, is gone from closed corporations in Brazil by case law, by judicial decisions. Then you have a limited liability. And this is perhaps is even more famous in the Brazilian context. In general, you'll find business people really unsettled by the degree of veil piercing under Brazilian law. Again, if you look at the corporations law, or even at the civil code, there are rules on veil piercing. You don't find anything exceptional there. You have veil piercing in cases of fraud and abuse. However, if you look at other statutes, or in some cases you have statutes, in others you have judicial decisions, you have numerous exceptions to limited liability. There is no limited liability at all in labor courts. I don't think this is an overstatement. I think it's just a neutral statement. Our statutes actually do not recognize limited liability for managers and controlling shareholders of financial institutions. You don't have limited liability for claims against consumers or for harm caused to the environment. That's very clear in the relevant statutes, and courts have upheld it. So, that's quite something. There are exceptions in numerous countries, but those are incredibly broad, the ones we see in Brazil. There's more, of course. I could go on and on. If you think about corporate groups, our corporations law says that each entity in a corporate group, you still have to recognize their separate boundaries. That's mostly gone in bankruptcy. We have very expensive use of substantive consolidation. And, here, it's missing a word, but for in our anti-corruption statute, you also have joint and several liability inside the corporate group, not only for controlled firms, but also for affiliates and controlling shareholders' unlawful acts. With respect to other elements of the corporate form, that's also what we see. So the degree of delegated management is also weaker in Brazil. So shareholders have far more power, and boards have far less power than you would see in other countries. One famous example is that in Brazil, shareholder agreements can bind directors' votes. But really, if you go and look into the powers shareholders have and into the powers boards have, you see a highly shareholder-centric system in Brazil. And of course, Brazil is a context that has many controlling shareholders. have limited time with respect to transferable shares. Here we don't see anything in the books, but you see practical hurdles associated with the high levels of private benefits of control that you have in Brazil and the interaction with a mandatory bid rule. This is a technical point. And also the effects of unlimited liability on shared transfers. And one of my favorite topics also, which is investor ownership. It's the case that in Brazil, for many of the important business corporations, they are not owned by shareholders that have primarily a financial interest in the firm, but they are owned, like, right, Sergio, by the state itself, and that can have important influence on the governance environment and corporate laws more generally. So then they have this question. I mean, how come? I mean, I'm not talking about like a detail of securities regulation. I mean, I'm really talking about the core attributes of the corporate form. And the question is, what explains the observed decorporatization in Brazil? And so the first one is not in the paper. Maybe I should develop it more, but I think it's the more obvious reaction is like nothing. Brazilian law is just crazy, out of control. I mean, we see it in so many areas, right? We dismiss things. This is so absolutely crazy. What have these people done? And actually, this is not. I think it's very plausible. You know, I don't want to discount it. That's why I include it in my presentation. But what I think what's difficult and interesting and challenging is that could it be efficient for our system to have developed this way? And I find it that it's hard to completely dismiss the efficient hypothesis that our system is in fact efficient, and I'll show you why very soon, or that in fact what we're seeing here is an adaptation that seeks to tackle distributional concerns in a highly unequal country that sees few other options to tackle inequality. So let me tell you a little bit about the efficiency argument. There are three versions of it. The first is the crazier, maybe the more provocative, but look, is that Brazil has the efficient regime. We are there, other countries are not. You know, we are really in the frontier. And you know that for many things that Brazil does, there are arguments in the international literature suggesting that this is the right thing to do. For instance, not have limited liability in cases of externality, such as externalities related to financial institutions. There are people say, well, you shouldn't have limited liabilities for banks or for people causing environmental harm. You know, consumers and workers, we call them in line economics literature non-adjusting creditors. So you can treat them. You can treat damages, harm caused to them as an externality as well. So the argument is there, you know, that the things that Brazil does is in fact efficient. I wouldn't argue that all the details of the Brazilian regime are efficient. That would be impossible. But some of the progressive elements of the Brazilian regime, if you can call it so, do have efficiency justifications that are shared by some mainstream authors. The second and perhaps more plausible efficiency interpretation is that Brazil's regime is efficient in view of its particular institutional environment. Being a developing country, it has possibly a deficient institutional environment. And maybe in view of that, the second best alternative is to have a very different corporate form. For example, perhaps in a system that has a very functional regulatory state that is able to regulate against environmental harm, maybe then it makes sense to have a limited liability, or can regulate very well financial institutions. Maybe then it makes sense to have limited liability. But what if you don't? We heard this morning that apparently our regulatory system does not work so well. So, well, maybe then one interesting adaptation would be to have unlimited liability. Well, maybe, I mean, this is actually what most scholars say. Well, you can have law. It's hard, you know, everywhere to be a minority shareholder in a closed corporation. But, you know, if you have a legal system that sufficiently protects minority investors, you can live with it because controlling shareholders won't steal too much Well, what if that's not the case in Brazil? I mean, in studies conducted in the 1990s suggested that Brazil had the highest levels of private benefits of control among all countries we studied. So if you don't have that, maybe then it becomes unfair or inefficient to have lock-in in a closed corporation context. So this could be an efficient adaptation to our context. Well, what if you cannot control managerial agency costs? Well, maybe then it makes sense to have a corporation statute that's uniquely shareholder-oriented in order to control managerial agency costs. And I could go on and on for all of the attributes. But I wanted also to explore the third possibility, which is that, which builds on the notion, and this notion is well established, that actually there are important complementarities among the different elements of the corporate form. So say you have limited liability. A creditor cannot go against the shareholder's assets. Well, but then it's a good thing that the shareholders cannot withdraw the assets from the firm. You know, hey, in Brazil, now shareholders can withdraw the assets from the firm. Well, maybe then it makes more sense before creditors are paid. This is what partial dissolution does. Well, maybe in that context, it makes more sense to permit creditors to go after the shareholders' assets. Of course, you're way more likely to give away control to managers if your entire patrimony is not at stake, right? If it is because of unlimited liability, maybe then you want to be a controlling shareholder and live in a system that in which managers are under a tight leash. Well, if you cannot have durability, because in fact, lock-in or entity shielding is really related to durability. Sometimes, say, a family wants to have the corporate form so that heirs won't get into disputes and the firm will die. This was very prevalent. This use of the corporate form for durability after the French Revolution imposed a system of legitima, right, in which you have a mandatory allocation of assets among the heirs. Well, durability now is also greatly diminished because of the reduction in lock-in. Maybe then you need other types of durable firms, such as through state ownership. So this is the puzzle here, right? It's hard to reject the notion. It's hard to evaluate what's going on, and it's hard to, without further study, reject the possibility that, in fact, what we see is not crazy, but an efficient adaptation, or just we are just right, and we got there before other countries. Of course, it's also possible that what's driving this deviation is not concerns about efficiency, but rather concerns about distribution. I mean, some of these rules might be driven by desires to help have-nots, workers, for sure, maybe, consumers, taxpayers, victims of environmental harm, minority shareholders. So it's possible that that plays a role. I mean, yesterday we are hearing about oblique ways to deal with the very high levels of inequality we have in Brazil in view of state budget constraints. So could that be playing a role? So that's also possible. Is that a Brazilian phenomenon or not? So this is something I've been struggling. With. In presentations in Brazil, at some point, I had a title called, "Is this a jabuticaba?" And then I got pushback saying, well, there is also jabuticaba in Paraguay and Venezuela. This is one comment. And the other one is that I haven't seen the laws of all other countries. And that's true, you know, I have not. So I'm not arguing here that this is unique to Brazil. I would love to, in fact, it's the opposite, right? I would love to see other examples of this trend, but I have not been able to see much. I mean, I go to other Latin American countries, I talk to people, I read the comparative literature. I see some of that in China. So I've had a Chinese scholar read the paper and think that it really resonates with Chinese reality. There are papers suggesting that there's far greater use of veil piercing in China, say compared to the US, and evidence suggesting that the other corporate attributes are also weaker. So maybe it's a developing country or global south adaptation, but I'm reluctant to press that claim. I only have real evidence on Brazil, though that is possible. So in terms of conclusion, I just want to cast doubt on the idea that this continued vitality of the corporate form is inevitable. In Brazil, we see some mitigation of these important corporate attributes. And suggesting that this can point to new directions for works on comparative corporate governance, showing that differences can be more profound than the ones identified so far, which have focused primarily on the level of investor protection afforded by different countries, and that the convergence versus persistent debate is insufficient. I mean, there is this debate about whether, in the face of globalization, corporate laws are converging towards a shareholder orientation, or if existing practices are just persisting because there is significant path dependence. But this in Brazil suggests that there's like newly minted innovation and actually coming from the developing world. So this is what I had, Mario, and thanks for letting me present the paper. I think Mario has this saying that part of what we do in law and development is study the gap between what we have here in terms of legal institutions and what we see in the core, like Katharina says. And I guess this is part of what I'm doing here, but what I think is really important is that to try to identify new categories that are not necessarily captured by the lenses of scholars in the North. So I think these developments are profound, but they are not captured because they're going on here and not directly resonating with developments elsewhere.